Welcome back. We're on to consideration, which is our fourth element for a binding contract. Consideration is the most crucial to setting up a valid contract. The other elements can be part of a non-contractual agreement, but only when the payment or a promise of exchange flows between that offerer and the offeree is it considered a binding contract. Considerations is what a person demands and generally must receive in order to make her or his promise legally binding. These requirements include each party must make a promise, perform an act, or refrain from doing something. This must be in exchange for a return promise, an act, or refrain. And third, what each party exchanges must have legal value. This is what distinguishes a contractual promise from a promise to make a gift. Courts generally do not inquire into the adequacy of consideration, which means equal economic value, because the value in which the exchange is made or the agreement is made is between the two parties and is considered valid. Capacity is our fifth element. Contractual capacity is the ability to understand that a contract is being made and its general meaning. Parties that have special rights to capacity would be minors, the intoxicated, and the mentally impaired. Protections for those who lack capacity would be disaffirmance, and this is a refusal to be bound by a previous legal commitment, but this must be done in a reasonable amount of time. Special circumstances may disaffirm a contract for necessities such as food, clothing, shelter, but remains liable for reasonable value of goods. Minors have special capacity as well. These are persons who have not yet reached the age of majority, which is 18 in most states, such as Missouri. Contracts are voidable and may be disaffirmed. If committed an act of fraud, the minor who lied about their age in most states allow them to disaffirm but may be held liable for the tort. Generally, parents are not liable for the contract and may be contractually bound. That minor may be if they are emancipated. Emancipated minors are those who are no longer under the legal control of their parents and are responsible for their contracts. Contracts of minors that cannot be disaffirmed would be the court-approved contracts, enlistments into the armed services, educational loans, and marriage contracts. Intoxicated is a person mentally impaired by voluntary use of drugs, alcohol, or inhalants. Can they understand their consequences of the contract? Courts typically allow disaffirmance only for those who are temporarily intoxicated that they do not even know they are contracting. If a judge holds that a person is a permanent state of alcoholism, the contract is void. Those that are mentally incapacitated are considered persons who are unable to understand the consequences of their contractual act. If one is considered permanently incapacitated, the contract would be considered void. If this is a temporary incapacitation, the contract could be voidable. Contractual capacity in organizations depend upon the scope of authority, and this is the range of contractual acts an organization has authorized an employee to do. The capacity to contract on behalf of an organization has to do with a delegation of authority or apparent authority. A delegation of authority is when an employer tells the employee they are authorized and in control. Apparent authority is employee's title of purchasing agent and is assumed to have the authority. A counterexample may be a salesperson in a shoe store. They have capacity to sell shoes, but they could not bind the store to control leasing a new store, such as the scope of authority is strictly to selling shoes. People acting outside their scope of authority generally are personally liable when the organization isn't. And our final element is legality. Legality would have to be a contract that is considered void or unenforceable because of an illegal act. Examples of illegal acts in contracts would be illegal lotteries, the enforcement to pay usury interest rates, which are above the maximum interest rate allowed by law, agreements involving illegal discrimination, those that obstruct legal procedures, agreements that are made without a required competency license, agreements that may affect a marriage negatively or restrain trade unreasonably, unreasonable agreements not to compete after termination in employment contracts, such as certain unrestrainable non-compete clauses. This is not an element, but it is something very important to address, is writing and having it in its proper form. Not all enforceable contracts have to be in writing. Oral contracts can be enforceable when one person offers to do something and the other agrees to do something in return. The statute of frauds gives you very specific types of contracts that must be in writing. This is a law stating that certain agreements are not enforceable in court unless they are evidenced by a signed writing. Example of these would be any sale of a good for over $500, the sale of an interest in real property such as land, buildings, or homes, something that would require more than 1 year to complete, or stand good for the debts of another or of an estate, and promises to give something of value in return for a promise of marriage. It's always good to have important contracts in writing. Requirements of writing vary by state. These may include the name of the parties, a description of the subject matter, price, quantity, signatures of both parties, and other essential terms such as time, delivery, and payment methods. Examples of contracts might be invoices, sales slips, checks, faxes, or letters can all qualify as writings if they contain a signature. Electronic signatures are a new form of approved contracts. What could discharge a contractual obligation? Well, discharge is the termination of contractual duties that ordinarily occur when the parties perform as promised. By performance, a complete performance would be done exactly as specified, and the other party must complete the duty, such as pay in full. Substantial performance are all but a minor duty done and may sue to receive payment less the cost of remaining work. Inferior performance would be a reason to discharge because one failed or left something essential out. Duties of non-breaching parties may be discharged, example, not pay. There's also discharge by initial terms. In a contract, agreements that will terminate at a specific date, event, or notice are able to be discharged. There's also a subsequent agreement. A contract could be discharged due to rescission, and this is undo entire contract and both parties are placed in the original position. Or there could be a substitution. Replace the old contract with a new one. There could be accord and satisfaction, which is agreed to change the obligation required and it is performed, or a novation, a release of one party from the duty of the performance and accept a substitute party. Discharge could also happen by impossibility of performance, and these would be extreme external conditions such as surprise wars, unexpected embargoes, or unique items destroyed. There could be delays of performance that do not discharge obligations, such as increased supply prices, worker strikes, or natural disasters. These all commonly include escape hatch language permitting modifications or terminations of performance without liability for damages in the event of a specified condition. By operation of law, such as bankruptcy, debts are discharged. Statute of limitations would be an operation of law, meaning time for enforcement expires. Or contract alterations, where the material change in the terms of the written contract are without the consent of the other party. When there is a breach of a contract, there are remedies, and these are actions or procedures followed to enforce a right or to compensate for an injury. A minor breach might be injured party continues to perform the contract duties, and there's money damages possibly. A major breach would be injured party does not need to continue contract duties, and there's a rescission and restitution where the contract is canceled and returned to position that they were before contracting. When there's money damages, there's payment to compensate for injury. They may require specific performance, such as a court order commanding breaching party to perform what was promised in the contract. Types of remedies when there is a breach are first compensatory, and these restore to the same financial position prior to the breach. Consequential damages or grants money for foreseeable related injuries caused by the breach. Punitive are additional monies to punish and make an example out of the defendant, such as fraud or intentional torts. Liquidation, where a specific amount written in the contract because actual damage amounts would be too difficult for the court to figure. And nominal damages, and these are a small amount is awarded for the legal wrong of breaching a contract, even if the plaintiff finds a replacement. Finally, factors affecting the choice of remedy might be the conflict of remedies. This is when the parties must choose a remedy when suing. Pursuing one remedy often rules out pursuing another. There may be a duty to mitigate the damages. Injured party must act to minimize harm done. There may be waivers. A party intentionally and explicitly gives up a contractual right. Statute of limitations, where the state law for setting a time limit for bringing a lawsuit has expired. Or bankruptcy, permit the discharge or excusing of debts. We've now discussed our 6 elements of a contract for a legal, binding, enforceable contract by law. Hope you have a better understanding of contracts.